Executive power in the United States encountered limits, of all things, during the third full week of June. First, a federal district court judge in Wyoming ruled the Bureau of Land Management lacks authority to regulate hydraulic fracturing on federal and Indian land. Then the Supreme Court let stand a lower court rule blocking President Barack Obama's program to shield millions of undocumented immigrants from deportation. It was a good week for separation of powers. Obama overworks executive action. He says Congress forces him to rely on the infamous pen and phone because it won't do his bidding. Someone should remind the former constitutional professor that Congress wasn't designed to bow to presidential will. In the frack case ruling, District Judge Scott Skavdal wrote, "Regulation of an activity must be by congressional authority, not administrative fiat." The issue, he said, was whether Congress gave the Department of the Interior, of which BLM is part, authority to regulate hydraulic fracturing. It has not, Skavdal ruled. In the immigration case, the Supreme Court upheld an appeals court ruling with an evenly split decision. The program in question deferred action on deportation of immigrants illegally in the United States who are parents of American citizens or of lawful permanent residents. 26 states challenged the plan. The appeals court had affirmed a ruling that the administration violated notice requirements and added a broader ruling that it exceeded statutory authority. House Speaker Paul Ryan said the Supreme Court vindicated Article 1 of the Constitution, which reserves to Congress all legislative powers. The President is not permitted to write laws, Ryan said. Only Congress is. The imperious Obama won't be chastened, of course, but his presidency is almost over. Because tests of executive branch authority are not likely to subside when Obama leaves office, a stiffening of the judicial spine is welcome. Both leading presidential contenders seem to share Obama's dangerously expansionist tendencies with powers of the office, so their honors have provided a needed reminder. The Constitution still applies. I'm Bob Tippie, editor of Oil and Gas Journal, and that's the editor's perspective, which appeared first in text at www.ogj.com on June 23, 2016.